Good morning. Good morning, members. It is time to start. We've also formed a quorum. So I call to order the meeting of the Bills Committee on Employment Amendment Bill 2017. First of all, let's elect a chairman. So we proceed to the election of chairman for the Bills Committee on Employment Amendment Bill 2017. I would like to follow Rule 21 of the House Rules as well as Appendix 4 to the House Rules when we elect the chairman. Nominations are to be received. The nomination has to be made orally to be supported by another member. Any nominations? Mr. Wong Ting Kwong, Honorable Wong Ting Kwong. Any seconder? Mr. Yu Si Wing, Mr. Chan Kok Kwan, second the nomination. Mr. Wong, do you accept the nomination? Yes, I do. Any other nominations, please? Any other nominations? I will just count 3, 2, 1. No other nominations. So, Mr. Wong Ting Kwong has been elected as the chair of this Bills Committee.
Okay.
Good morning, members. Employment Amendment Bill 2017. Now the Bills Committee formally starts its meeting. Can I check with you if you would like to elect a deputy chairman? Nobody indicates any need for that. Well, in that case, let's meet with the administration. We have received from Mr. Andrew Wen a correspondence addressed to the Secretariat who would like to join the Bills Committee according to Rule 23B and C of the rules. If there is a late membership but not on the ground of being indisposed at the time membership nomination is called for, and he was not out of time at the time, then it's up to the Bills Committee to decide whether to accept late membership application. Do you accept Mr. Andrew Wen's application? You agree? Mr. Shu Kao Fai agrees. He proposes. Any seconder? Many of you. Fernando Zhang, Wu Chiu Wai, and Pun Chiu Ping. All right, let's notify Mr. Andrew Wen that he has been admitted to the Bills Committee. We have Ms. Melody Luke, Assistant Commissioner for Labor, Mr. Raymond Liang, Chief Labor Officer, Labor Relations, and Ms. Cecilia Chen, Senior Labor Officer, Labor Relations, all from the Labor Department. Welcome, ladies and gentlemen. So first of all, I'll give the floor to the administration. Please give us a briefing on the bill. Members, you may want to refer to the legislative brief. File reference is LD LAB CR 38/706(C), as well as the Legal Services Division report, paper LS 68/16 to 17. there's also a background brief prepared by the Secretariat. CB bracket 2 1642/16 to 17 bracket 02. This bill is actually similar to the bill discussed by the Legislative by the last term, except for the ceiling of the further sum. It would now be enhanced from $50,000 to $72,500. Administration, please. Thank you, Mr. Chairman. For the Employment Amendment Bill 2017, well, essentially it is the same as the Employment Amendment Bill 2016, except for the ceiling for the further sum. In the 2016 bill, it was kept at $50,000. Now it will be $72,500. I would like to walk you through the proposals in the bill. The purpose of the bill is mainly to empower the Labor Tribunal to do the following. That is, when there is an employee who has been unreasonably and unlawfully dismissed, and if the employee wishes to be reinstated, then the Labor Department does not have to get the consent of the employer before making an order of reinstatement. The ordinance as it stands, for an employee who has been unreasonably and unlawfully dismissed, if he seeks a reinstatement, the Labor Tribunal must get the consent of both the employer and the employee before making such an order. Well, the purpose of the bill is to enable the LT to make an order without the consent of the employer. So that's the bill's objective. In simple terms, what we propose to do is that if the Labor Tribunal, the LT, receives such a claim that is an employee has been unreasonably and unlawfully dismissed, that is UUD, now the tribunal may make an order if it thinks that it is appropriate to make an order and that it would be reasonably practicable for the employer to do so, then the LT will make such an order. If the employer doesn't comply with the order after an order has been made, then the employer has to pay a further sum to the employee. According to the bill, it will be set at 3 times the employee's average monthly wages, subject to a maximum of $72,500. If the employer fails to pay this sum, then he is committing a criminal offense. If an employer doesn't comply with a LT order, then there will be a maximum fine of $350,000 and an imprisonment term of up to 3 years. So the same kind of penalty as other all offenses. What is meant by unreasonably and unlawfully dismissed? There is a clear definition in the existing legislation. Now, if an employer dismisses an employee not for a valid reason. By valid reason, it means the conduct of the employee, his or her capability or qualification for performing the job, etc. Then it will be unreasonable. Now, for an unreasonable dismissal to be unlawful as well, then it means that if the dismissal is in contravention of labor legislation, including the following grounds: dismissal during pregnancy and maternity leave, during paid sick leave, after work-related injury, and etc., or by reason of the employee exercising trade union rights, then it will be unlawful. The existing bill is in fact based on the 2016 bill. In year 2016, we submitted a similar bill. At that time, In the event that the employer fails to pay the first sum, fails to comply with the LT order, the further sum would be kept at $50,000. There were divergent views, and as usual, we referred the views to the Labor Advisory Board to seek further comments from the LAB and to check what the employer and employee representatives think. The LAB at the time listened to the views of the Bills Committee. There was a discussion, and then there was a consensus on 2 points. First of all, the original legislative intent of the 2016 bill should be kept, but then the ceiling of the further sum can be raised. So upon discussion, it was said that instead of $50,000, it should be enhanced to $72,500. Therefore, we would like to propose a CSA, and that's it I would like to say by way of a briefing. Thank you, Chair. Well, during the 2016 deliberation, the Secretariat has written a few times to the administration. Maybe our legal advisor can also elaborate on those letters sent. Thank you, Chair. I think you have received copies of 4 letters, including the Chinese and the English versions. We have written to the administration twice, and we have also received replies from the administration. They are all in relation to the legal issues in the Employment Amendment Bill 2016. We asked a few questions and were given very detailed answers. For the Employment Amendment Bill 2017, its content is basically the same as the 2016 bill, other than the further sum. So the LSD has not repeated the same questions, but we are producing copies of the 4 letters so as to let you know what questions have been put to the administration and the replies we have received from them. And when we reach the stage of clause by clause, I will raise the questions again with the administration so that they have the opportunity to give you a detailed reply, and the members will have a better understanding about the legal aspect of the relevant provisions. So just want to let members understand that we have reproduced the 4 letters for you. Thank you. For the Employment Amendment Bill 2016, there was very detailed scrutiny by the Bills Committee. But then, as a result of the divergent views concerning the figure of $50,000, the figure of $50,000 was the outcome of discussion of the LAB. If we would like to change the figure, it means that we needed to consult the LAB again, and therefore time was needed to do so, and that's the background of the 2017 bill. I now open the floor to members for questions. Mr. Shukafai, followed by Mr. Wu Chi-wai. Thank you, Chair. A question for the department for unreasonable dismissal. I think there were a few examples in the past 3 years. Can you cite more examples for us?
Sorry, Chief.
The AD, Assistant Commissioner, rather. Thank you, Mr. Chiu, for the question. With regard to, well, let me put it more clearly. The bill, or this bill, deals with unreasonable and unlawful dismissal. So there are 2 conditions to be fulfilled. As for unreasonable dismissal, since this part of the bill or this part of the law was passed in 1997, in about 20 years, about 7.7% or 8% to round up of the cases were related to claims in respect of unreasonable dismissal. The employees believed that they were dismissed unreasonably. As for UUD, claims under UUD, the percentage was less than 2%. In respect of unreasonable dismissal, about 8%. UUD, 1.8%. So the two added together, 9%. Am I correct? You may say so. But let me put it more clearly. The number not necessarily mean that it is the nature of the case is as it is. Now, when an employee came for a conciliation service at the Labor Department, the employee felt that he or she was unreasonably dismissed. Let me explain to you the condition. As long as the dismissal is considered to be without a valid reason by the employee, then the employee can claim for a conciliation arrangement. And a valid reason includes certain, redundancy or genuine operation requirement. Say, for example, if a security guard is at the age of 65, if he is older than 65, he cannot continue his service. That is according to the law, and therefore, if the person is dismissed under such circumstances, that is not without a valid reason. If there is no valid reason, then conciliation is maybe the way to deal with it. If the employee feels that he is dismissed without a valid reason, then he comes for conciliation at the Labor Department. We invited both parties to come along, and then we invite both parties to come along and then try to understand the details of the case. According to our experience, about 70% of the cases can be resolved through conciliation. Yes. Are there actual cases or examples which are rather controversial? Can you cite one or two controversial examples? In particular, the employers didn't agree. Thank you, Chairman. Let me focus on UUD claims under UUD, because the bill is about this. Say, if a member, if an employee lodge a claim, we came across a case in which the employee was dismissed during pregnancy. I understand this point, but it's still controversial. Well, there is no controversial on pregnancy. Well, the employer loses, certainly. Is there any case in which, well, of course, work-related injury, pregnancy, if the employer didn't pay, then or dismissed the worker, then he loses as well. Well, there are controversies over the pregnancy cases. What about cases other than that? Mrs. Siu asked whether there were such cases. We discussed one at the previous session of the LegCo. Now, say there was a dispute over work. Say in respect of working hours, there was a dispute. The employee was dismissed. Now, some members from the Labour constituency claimed that people were dismissed because of difference in political stance or because of engaging in trade union activities. Can I speak on this? I think the department is trying to dodge the questions, so I allow the member to speak. I don't challenge you. I just want to ask whether there is any time limit for each member. Well, there aren't too many members who want to ask questions, so there will be no time limit. We can engage in more in-depth discussion. I should have interjected. Well, if you raise your hand, I allow you the floor. I just want to clarify this. That is a dispute in respect of pregnancy. But what about those pregnancy and then well, there is no discussion on pregnancy. The employer loses. Let me give you an example. Now, the issue is faked work-related injury. I have dealt with many such cases. There is a claim of work-related injury. Then our company will have to go through the steps, give lighter work to the worker. The person has been in that place for a year or so, and then I think he has to go back to his original position to work. And then he said, I still have pain. Then we still have to deal with it, and we dismiss the person. But the person then claims that he's a member of the union, and also he suffers from work-related injury. We come before the Labour Tribunal. The employer lost the case because they tend to support the workers. I've handled several such cases. I think the point raised by Mr. Yik is also experienced by my company. The conflict was not between the employer and the employee. We had employee compensation insurance, and we have 100% compensation because we added the loading. The dispute was between the insurance company and the employee, and I continued to pay salary. As for getting the doctor's certificate, the employee was unable to obtain the doctor's certificate. The employee therefore has to go to work. But the employee refused to do this and refused to do that. And then I finally gave him a desk, and he was asked to sit at the desk. And finally, he asked the LD to conduct a determination, and it was 1% work-related injury. And that case lasted for 3.5 years. The employee hurt his leg and claimed pain. Now the insurance company paid all the cost. Well, in fact, I have not finished with my question. I welcome anybody participating in the discussion. Well, I just want to ask Ms. Lau and Mr. Yik. I just want to put the questions to Ms. Lau and also Mr. Yik. Chairman, let me suggest that let us have a time limit for each member. Yes, I've already started. Allowed you the discussion. Yeah, this is the first meeting I want to engage in a dialogue with the officials. I'm glad that there is improvement to employee protection. The amendment of the sum for UUD, the compensation will just be 3 times of the average salary, or $72.5 thousand, 50,000, or 72,500. It is a small sum. What I don't want to label the employers. Now, the issue is it is UUD. I think there should be better protection to the employees. It is not easy to find jobs. And since one feels that one is unreasonably and unlawfully dismissed, that one has to go through all the process of litigation, and that is also very tiring. I think it is better to enhance the amount to, say, $100,000 or 6 months of the Well, you are in the line. I just thought that you are going to engage in a discussion with Mr. Xiu. Well, you can discuss the issue of pregnancy. So how long will this round take? Because I'm in a hurry. I have to go to Big Oak. Okay, I give you the floor. Okay, I give you the floor first. The Commissioner, can you answer Ms. Lau's question? I have not finished, Mr. Chairman. Now you cover the UUD, and therefore there should be better protection to the employees. Is it possible to make further changes? This is the protection against UUD. Will you also have any idea as to when you will deal with unreasonable dismissal? As for UD, unlawful dismissal, let me give you a more detailed explanation. Unlawful dismissal is not just limited to the further sum of $72,500. Under UUD, there are 2 claims to be made. First, the terminal sum. This is terminal payments. This is according to the law, and that includes notice in lieu of notice, and also the leave balance and things like that. The second sum is that if the dismissal is unlawful, the compensation can be claimed against the employer up to $150,000. So under UUD, there will be 2 types of compensations. If the employee asks for reinstatement and the LT or the court awards an RI, and if the employer refused to implement the RI, then there will be this sum. So if it is UD, then the employee will get the terminal payments and also compensation up to $150,000 and also $72,500.
So that's about the claim under UUD. In 2016, we didn't have time to deal with the reinstatement bill. Mr. Xiu, if I may pick up the points made by the 2 members. Mr. Yik said that somebody may fake a work injury and they were not able to get coverage of a medical certificate. Can you confirm that as long as somebody claims that he is in pain, he can still get compensation without a medical certificate? Like in the case of the chairman, he said that there was somebody who had gone to all hospitals and still couldn't get a medical certificate. Well, that's about compensation for work injury. Well, an employee has to go back to work if he is not issued with a medical certificate. If there's no reason for him to be absent from work, then in this case he has to resume his work. I think in the case of the cited by the chair, maybe the employee will still go back to work, but then the performance was unsatisfactory. Well, I want to pick up that point. Well, he hasn't got a medical certificate. I have invited him to come back to work. He's supposed to move the goods, and he said he can't, and yet he can't type, and so he just sits there. What can I do? Well, according to the existing provisions, the employee has to get an assessment of his work injury. The chair mentioned one type of work injury cases among many. I can cite another example. Say, for example, an employee is in a sort of an extreme case. Pardon me for using this word. Say, for example, there is amputation of one arm. He reports to work, but he won't be covered by a medical certificate for medical leave for a period of time. Usually, the doctor will wait for the injury to stabilize before making an assessment. So there will be a window. He has to go back to work, but then he is not covered by a medical certificate, and yet his physical health has changed, and that's the time when he's awaiting medical assessment. Mr. Chairman, let me sort of use the same so-called extreme example. There is an employee who has amputation of arm, but what would happen if the doctor says that he can resume his normal work, and yet he hasn't really recovered? So who has the final say? 3 years or 30 years? Well, let me share my experience with you for the sake of a discussion. In the case of disability, it is clear that even upon recovery, the employee cannot resume his previous work. I think in most cases, the employer will make the proper arrangements. Seldom have we seen disputes. This is quite rare for the LT cases. I referred to the case in my company. It was extreme. Well, it was a matter of spraining his ankle while walking up the stairs in our own company. He went to get an X-ray examination. There was a slight bone fracture, but then it dragged on for a few years. In the course of it, for the medical certificates issued by the doctor, well, in fact, the insurance company followed him and took photographs. Evidence was gathered. It was found that he was doing part-time work for the McDonald's, and then he went to all hospitals in Hong Kong. Medical doctors didn't want to deal with him. He was trying to get a medical certificate, so he couldn't help it, and he had to resume work. And he was a sales representative at the retail outlet. He just sat there. He didn't get up to greet customers coming into the shop, so he just stayed put, and it was sort of an obstruction. He sat there, and then the other sales representatives couldn't sort of go up to the counter because it was standing. It was obstructing. And then I gave him a desk in the office, and he had nothing to do. and every day he would say that he had pain here and there. When he said that he was in pain, then he had to be given leave to go to see a doctor. Sorry, point of order. Well, at 9:20, there will be an official visit to the Pig Oak prison. That is the subcommittee on the rights of children. I have come here wishing that we can have a chance to discuss the bill. So can you impose a time limit? I asked this question because I would like to know why there were so many cases. Well, when the LT determines the case, then we know what to do. That's in relation to UUD. The next, Mr. Wu, 5 minutes. Would that be all right? I think you spent too much time on that. What I want to say is that employers and employees may apply different yardsticks when they judge a matter. If we don't have difference of opinions between employers and employees, then we can have dispensed with the legislation. Now here we are talking about UUD, unreasonably and unlawfully dismissed. Take the example of a pregnant lady. Yes, they are entitled to maternity leave 4 weeks before birth and 6 weeks afterwards. Now, if somebody is dismissed during their pregnancy, even if compensation has been fully given, I think it will be difficult to get another job because the pregnancy is obvious, and then many employers may not want to employ a pregnant employee. Well, in this case, the loss suffered will be much greater than what she is entitled to under the compensation mechanism. I want to know whether there is another channel for this employee to assert her rights. Ms. Look, yes, there are a few elements under UUD. Yes, you have told us. It's a matter of coming up with the total sum. Now, in fact, employers will just try to check whether it is better and he can gain by firing the employee. If the employee has got all that she is entitled to under the mechanism, is there an extra channel? Now, for the loss suffered by the employee as a result of the dismissal, first of all, we have the $150,000 cap for the compensation. Yes, I know that you have said so. Now, if the loss is greater than the statutory compensation of $150,000, the law doesn't prevent the employee from seeking damage by way of a civil action. In the past, there were successful cases. Well, you talk about the maximum amount, and it is pitched at $150,000. Please tell us the basis of such a figure. According to the EO, when the LT makes a decision on the amount of compensation, the employer will look at the actual circumstances, the length of service of the employee, under what circumstances the dismissal was made, and also the loss suffered by the employee, and also the chance that the employee can get an alternative job, and also the whether the employee played a part in causing the dismissal, and also other compensation available to the employee. This has been written into the EO, and such other factors to be considered by the LT. If I may ask another question, we are talking about UUD. Say, for example, we have a pregnant lady and her dismissal was due to committing something which is criminal. You mean criminal? No. Say, for example, causing some losses to the company. Well, you're talking about unreasonable. As long as there is a criminal element, then it is not UUD. Well, for criminal offenses, then the employer must consider that. So this kind of dismissal will not be dealt with here. Whenever there is a criminal offense, then it will always be a reasonable dismissal. So unless you take away the word criminal from your question, when it is a reasonable dismissal, then it is justified, right? Yes. Next, Fernando Zhang. I hope there are voices representing the labor sector. Because so far we have only heard from the side of the employers. Now, when the LT has determined that it is a case of UUD, I think it is quite rare. I hope the administration can tell us how many such cases we have got. Now, at this stage, if the employer would still like to have reinstatement, but in fact, I suspect that the relationship has been destroyed because there is a lack of trust. It is very, very rare for the employee wishing to be reinstated. We have reason to believe that it must be a very large-scale organization rather than a small one, because if the employer still has to see the employee day in, day out, it will be a big problem. For the employee to wish to remain in the organization, probably there are many reasons. Let me assume, and I'm not sure whether there have been previous cases, maybe the employee is a member of the trade union, and he plays a very important role despite the adversity. Well, the bill proposes that if the employer doesn't agree to the reinstatement, then there will be a fine up to 72,500. If you fail to pay this sum, it will be criminal. However, by paying for that, then you are permitted and you're relieved from reinstatement. My question is, in the case of a large organization and this employee is a trade union representative, the employer doesn't like him, and therefore the employee has been unreasonably and unlawfully dismissed, and the labor tribunal has already made a decision and agrees to that. And then the cost or the price to pay is $72,500, and then they can sort of remove this trade union representative. So how can you say that employees who represent trade union members don't have anything to worry about? How can you convince us that it is a proper legislation? Why can't you impose a criminal liability on the employer when he refuses to comply with the RI order?
Well, let me explain UUD and its cost on the employer. The terminal payments, the compensations, and also the RI order or RE order. They are this is a kind of civil liability. Under UUD, if there is adequate evidence, the employer is in breach of has committed a criminal offense and may be prosecuted. There are criminal and civil liabilities. As for the $72,500, as a matter of perspective, whether the amount is adequate or not. But this amount was agreed by the LAB after discussion. Well, I refer to the employer refusing to follow or comply with a court order, and he can get away with it by paying. Now, if it is UUD, he has to he has to face criminal liability. But the situation is about the RI. This is an order awarded by the court, and he refuses to comply, and he can just pay it off. How can that be? The employers and employees discussed this for many rounds, and both sides agreed that if the court or the LT has issued a RE or RI order, and the employer refuses to comply, then it should better be dealt with by a further sum. This will avoid further complicated legal procedures, and this is a rather substantive compensation. I think the administration seems to put the LAB as the highest level of the legislative body. Their proposal is the best, and if they have agreed, then we will have to follow. But this is the Legislative Council, which makes the law. I think this has been discussed. The LAB is not supreme. Wherever you stand, whether you represent the employers or employees' interests, you also need to respect the LAB. Of course, we do respect them, but I hope the government knows that the administration also respects us. We represent the people, we represent the workers. Well, the Bureau cannot stop us from doing the things we have to do. Mr. Poon and then Mr. Ho. We have had a long discussion on this bill. It has been delayed. The further sum was discussed. In the last term, the members felt that the amount was too small because the issue had been discussed for a long time, and inflation would be even it couldn't even catch up with inflation. And finally, the administration has come up with the $72,500. I think it's a token. It's harder to get this sum rather than winning Mark 6. I think this cannot be, should not be delayed. Under UUD, the employee is entitled for reinstatement or re-engagement. And if it is not complied with, then if the employer does not comply, then the further sum will have to be paid. If there was no discussion, the administration wouldn't have put the bill before us, and political reality tells us that the bill cannot get passed in this council. The LAB has had a long discussion, and I therefore respect the bill, or the proposals in the bill. The further sum is set at $72,500. With longer discussion, the amount it has been eaten by inflation. Now you put it under 13 NAB. Is there any mechanism to adjust the amount according to inflation or because of inflation? Now we want to get the bill passed. Now, if I just want to know what is the attitude of the administration, will you retract the bill if there is further discussion? First, on the $72,500. This is the outcome of negotiation between employers and employees. We are not able to see when it will be amended, because the bill has yet to be passed. At present, we have no plan to introduce an adjustment mechanism. And if there are further views, then we will follow the established mechanism. We'll bring the new ideas back to the LAB for further discussion, and depending on the outcome, we will decide on how to deal with the bill. If it is a substantial change, then we'll have to consult the LAB again. In other words, if somebody moves an amendment to the bill, you will bring it back to the LAB, or you just put it before the Council for the vote. Well, our established practice is to bring it back to the LAB for further consultation. Then it will be delayed again. Next, Ho Kai-ming, and then next, followed by Leung Yiu-chung. I think it's too far to bring this reinstatement order to discuss with work injuries. As for a small company, one may not ask for reinstatement order. If it's a big company, you'll certainly find a place for that person. Now, the further sum is $72,500 in respect of the reinstatement order. How many workers will be benefited in a year? I think the number will be too small, maybe 1 or 2 cases per year. It is, I've asked the question, but it has not been answered. As for reinstatement order, in respect of associate companies, but if it is the associated company is very remote, say I work in the central, but the reinstatement order is for me to work in Tin Shui Wai. This may be a deliberate redeployment. So this is just to force the employee to quit. And if the employee quits, then or if the arrangement is to force the employee to quit, then will the employee be paid the $72,500? Let me answer the first question first. In the past 5 years, with regard to all the claims dealt with by the LAB, this category accounted for about 2% of the claims. Say about 25 cases out of 2,000 asked for RI or RE. So about that's about the current situation under the current legislative framework. 5 cases per year on average. For RI and RE under UUD. Am I correct? Correct. Now, let me follow Mr. Ho's question. Of the 5 RI or RE, there is no compensation. Well, the 25 cases are claims. 25 claims. They are claims. Were they established? Well, let me give you some data. Among the 25 cases, with the help of the LD, 9 cases were resolved. After conciliation, they agreed on the reinstatement, and in some cases they resolved through a payment. 9 altogether. As the remaining 16, there was no conciliation, and the cases were referred to the LD for determination. You referred to 5 cases. 5 out of 25 were given RI, right? No. On average, 5 such claims per year. 5 such claims. How many RIs have been issued? RI orders. Now, 25 cases in 5 years, you said that 1 case of reinstatement. Now, 5 cases. 1 out of 25 reinstatement. 4 compensation. Is it the case? They pay and solve the problem. And 16 cases were not resolved and were referred to the LT. The LT is a court. What was the outcome of the determination by the LT? The determination by the LT. That's the question. 4. 4 cases agreed to settle by payment, and then 2 cases the employees lost. 2 cases deferred by the LT. 3 cases withdrawn by the employees, and then 5 cases the case lapsed because the employees didn't pursue the case any further. So it's not of no use. So when it came before the LT, most were withdrawn. Can the department provide the detail in writing? Well, we cannot provide the specifics. Can we provide general? The reasons for bringing the case to LT. Now, that was the issue of pregnancy. So 4 weeks and 6 weeks. Well, it's not 4 and 6, but it's about 10 weeks. I think that's a wrong message if you still adhere to the principle of 4 weeks plus 6 weeks.
I think in the
past it was difficult to make an RI or RE order. Main reason being that the court had to secure the consent of the employer, and that's why the administration would like to amend the law, and that's the crux of the matter. At that time, we objected strongly to the need to get the consent, not the consent of the employee, but the consent of the employer. It was just impossible. Now, the court was supposed to ask the employer whether the employer would like to have reinstatement rather than an order being made by the court. Therefore, we resented the idea. Maybe the administration also thought that it was improper. In fact, it was a violation of basic rights, and that's why the administration has come up with this amendment. That is, there's no need for the consent of the employer as long as the court thinks that it is appropriate and it is reasonably practicable, then an RE or RI order will be made. Now, I think it means much more to the employee, but of course, first of all, it must be a case of UUD, both unreasonable and unlawful, and the court must think that it is appropriate to reinstate or re-engage. So the threshold is indeed very high. But still, we may have employers failing to comply with the court order, and yet the maximum penalty will be a mere $72,500. Where does this figure come from? Last year it was $50,000, so $50,000 plus less than half of the $50,000. Therefore, protection of basic rights of the employees is still inadequate. I'd like to share my experience with you. The department can comment on it. For your claim to succeed, I think we are mainly talking about employees who are fighting for their interests, like with a trade union background, and in the course of it has been dismissed. Otherwise, I don't think it will be easy to get a reinstatement or re-engagement order, because you need to meet both legs, unreasonable and unlawful. There are 5 factors. There is substantial reason. I'm sure it is easy for the employer to come up with a reason of substance. So unreasonableness would be easy for the employer to get by, though not so the case for unlawful. Now, for an employee to fight for reinstatement, I'm sure there must be a very strong reason behind it. You can imagine that reinstatement causes a lot of embarrassment. It isn't good for either side. So reinstatement is claimed for, and failure to meet the requirement would only fetch a maximum fine of $72,500. We've asked for $100,000. It isn't a large sum, but the LAB won't agree to it. Maybe the LAB would like to show its superiority and comes back with $72,500. To me, I say that it should be $100,000, but of course Fernando has said that it should attract a criminal liability. Whether we respect the LAB, well, in fact, we don't want the LAB to impose constraints on us. You have always said that you need to go back to the LAB, and that's why it has been delayed for so long. I would still ask for $100,000, but you always say that you have to go back to the LAB. Your time is up, Department. Please comment on the proposal from Mr. Leung Yu Chong. Well, for the further sum, I have to emphasize that the administration has no intention to restrict the powers of the LegCo. We don't mean that. We always respect your views. But then for labor matters, we have to emphasize that the Labor Advisory Board is a effective mechanism for the employers and employees to discuss. Last year, we had the 2016 bill. Members' views were divergent, and we have forwarded all your views to the LAB. They took a very careful look, and then they have come back with this figure. So it's not a matter of whether we respect or not. We will certainly respect the views of the LegCo, but at the same time we have to respect the outcome of the discussion of the LAB. Mr. Leung, I think the administration has given an answer. As the chair, I would like to talk about the legislative process. We have got 69 members. If we fail to come to a consensus, anybody may propose an amendment. But then if under the system of split voting, the CSA is not endorsed, in the event that the administration is to withdraw the bill, then the $72,500 as a further sum for UUD will just be gone. So perhaps we should consider the matter. Should we ignore totally the outcome of the LAB deliberation and we go our own way thinking that we are discharging our own duty? Mr. Chairman, I think the trade union representatives are really concerned. I can understand. Why don't we hold a public hearing so that those fighting for trade union interests can come here to express their views? Well, I will invite your views on this. But I think members know full well employer-employee relationship. Mr. Andrew Wen, Mr. Chairman, I want to echo the request of Mr. Leung Yiu-chung. It is exactly because of what you have said. Of course, we are aware of the risk. We may want to propose a CSA. The government will not budge at all and will threaten to withdraw the bill. But it is still worth a while to have a round of discussion. I think the labor sector will be most unhappy if we can't go ahead. I don't have any fresh arguments. Of course, we want to have improvements. I won't say that it is not reasonable, but then it is a bit difficult to understand. First of all, it is confined to some very extreme cases. In the case of an unlawful dismissal, it will attract a criminal liability. Now, it is both unreasonable and unlawful, and the court has made an RE or RI order. Non-compliance won't catch a criminal liability. It is at most a fine. So logically, it doesn't stand. Of course, I understand from the AC that we have to take into account the views of the LAB. Not that we don't respect the LAB, but then you need to justify your argument. And I don't think you have. As to the new figure here, I think even if you try to work on the basis of the figure proposed last term, it isn't a matter of 1.5 times of the original figure. Well, the relationship has already been strained because it's a case of UUD, and the court has made a RE or RI order. The employee is willing to go back, and yet the employer won't allow him to come back. Probably we are talking about trade union representatives. In the case of non-compliance, the penalty is still $72,500. So it is not proportionate. Chair, you have stated the problem. First of all, I think the department needs to go back and reconsider our views. Second, perhaps we should hold a public hearing, and then we listen to the views of the labor sector, and then we come to an overall judgment. Maybe a member would like to move a CSA, hoping that we can still be trying our best. Well, what you have said has already been stated by many members, so maybe a quick reply from the department, please. Thank you, Chair. Thank you, Member, for your question. I just want to say that for the further sum, it is proposed to be 72,500. It isn't so much that we want to dispense with the criminal liability. We are thinking in terms of the actual benefit to be given to the employee. Well, even if we impose a criminal liability in the case of non-compliance with the court order, the employee won't gain from it, and yet the loss is a real one. The LAB did visit this topic, and what we can see is that what we propose to do is to provide for a further sum so as to compensate the employee. In this way, the employee will stand to benefit from it instantly, and then procedural-wise, it will be a very quick one. Probably we can revisit this at the cross-by-cross stage. This will be written into the LT's order on RE or RI. In other words, as soon as it is found that the employer hasn't reinstated the employee, then the employee can instantly claim this sum from the employer without having to go through the court procedures, which can be lengthy again, so as to ask the court to judge whether it has been unlawful and unreasonable. So we've struck a balance. We want to see a quick solution to the problem, and we hope that the employee will be given some compensation. Mr. Chairman, I understand, but it seems that the department hasn't really heard what we said. It is neither here nor there for you to come up with such a proposal. Can I just supplement a point? Which way would you like to go? Which way you like the pendulum to swing? Whenever we try to strike a balance, we can't be overdoing in either in any particular direction. A question about the 25 cases. How many of them had a monthly pay over $24,000 a month? I don't have the figures with me. I have cited the figure of $24,000. Now it is either 3 times the monthly wage or $72,500. So unless you earn more than $24,000, you won't get the maximum. So please tell us about the details of the 25 cases. If all the monthly wages in such cases have been lower than $24,000, then there will be a strong deterrent effect. But on the other hand, if people have been earning $50,000, $60,000 or $100,000 in those 25 cases, we have to reconsider whether the proposal has deterrent effect. So please give us a reply in writing, because in any event, you have been invited to give us the details about the 25 cases. Well, if we are talking about a pilot like Mr. Tam, then it will be a huge sum of money. Well, don't talk about that. Well, if it is not going to be effective, say if all those involved are high salary earners, then it's a different story. And then for the RE/RI order, now you talk about 2 scenarios, engagement and reinstatement. Let me clarify with you, because I'm afraid I get confused.
Though the terms are comparable, something may have gone. Say, for example, the long service pay. Say one has worked for 10 years, he is dismissed. That is a reinstatement order. It's not a reinstatement, but it is a re-engagement or re-employment. You give him a new contract, put him in a new position, though the wage remains unchanged. Will there be any loss of seniority in calculating LSP, or the loss of year of service because the old contract, employment contract, has been terminated? As for there can be priorities and benefits, employment benefits given to employees because of his years of service. Say, for example, priority of getting on board for employees of airlines is based on a year of service. So if it is a re-employment and your previous length of employment has been discounted, then you lose out. As for re-engagement, there's a clear definition. It is not counted again, counting from the very beginning. Let me explain. As for reinstatement, it means that there is no variation in the terms of employment of the contract. As for re-engagement, the law puts it very clearly that it should be on terms comparable to original terms of employment. And this re-engagement will not affect the year of service. This is not an old contract. This is not the ending of an old contract and beginning of a new contract. One is just transferred from one department, say for example accounting office, to another department, sales. The terms of employment should be comparable. Well, let me give you an example. Say an engineer, a fresh graduate, and is in Scheme A of the company. He's in the registered engineer program, and then he is unreasonably dismissed, and then you have the reinstatement order. You are transferred to the accounting office. The accounting office, I pay you the same amount of salary, but you don't have the reason for joining the company because you want to join this company so as to be trained to obtain a certain qualification. How can you deal with this? Let me stress that the re-engagement order is not to be agreed upon by the employee and employer. It is an order awarded by the LT. The LT, in considering the claim, and if a certain proposal is made to the employer, then made by the employer, then the employee should also give his view in respect of the offer to be made by the employer, and then the LT will consider whether the terms can be regarded as comparable terms. The LT will make a ruling. Now that's why the $72,500 is very important. Now say for example, I spend a lot of efforts to complete the training, but now you dismiss me in the middle, and then the LT awards the order, and then you do not fulfill the order, then you just pay me $72,500, and I will not be able to get another company to employ me for this training scheme. This is possible. The employer may say that I've got another person to replace you, and in my company I have 5 trainees, so since you have been dismissed, someone has taken up your place. I cannot reinstate you. The LT may award the order, and even if the order is awarded, then the employer can pay $72,500 and get himself out of it. Now you want to have the further sum, you propose a further sum in order to force people to agree, but you cannot force people to agree. Mr. Yik, the Liberal Party has all along respects the decision of the LAB, and we support everything agreed by the LAB. Now, Chairman, we've cited examples, misbehavior, These were extreme cases of misbehavior. Then the representatives of the labor unions will also cite extreme cases of misbehavior by employers. I will get an employee, I want the situation to be harmonious because he helps me to make profits. Now the situation here is very special. It's UUD. You force me to re-employ the person, and we are at odds with each other. So there must be there should be a way out. The Liberal Party supports the Liberal Party supports the LAB's decision or preference. Please do not delay. Mr. Yu, the department has provided the numbers. 6 out of 25 were resolved. 16 were unresolved. So the problem is with the 16 cases. The employees do not find the reinstatement meaningful. Even if they lodge their claims, they may not be successful. The employees may feel that the employers may make their life difficult after reinstatement. They know that it's meaningless to be reinstated. Well, I'll just give you a desk and you just sit there. You just waste your time, though you get some money for that. Now, 16 cases were unresolved in 5 years, and now there is the proposal that since the court has issued the order, you have a problem, then the employer pays 3 months' salary as a way out. If the 16 cases, if the law is enacted, then these 16 cases will be compensated. This provision, therefore, can protect the employees, can provide compensation to the employees, and then the employers will have the responsibility to pay. My concern is about the amount. Is there any mechanism, say, to adjust the amount, say, according to inflation or what? Otherwise, after 10 years, then 72,500 will be too small, and you'll have to write up the law again. In fact, the department has answered the question. But please answer the question again concisely. We have no intention to have an automatic adjustment mechanism. Just like other provisions of the labor laws, we will amend the law if there is a need to do so. Next, Mr. Luke. Thank you. The Commissioner did not respond to the time on the time of revision. I'm disappointed. We respect the decision of the LAB, but we know that the Labour side accepted this reluctantly because having something is better than having nothing. And the employers have been adamant in the discussion process. There should be a timetable for reviewing the $72,500. If the Commissioner is not able to give us a timetable now, they should go back and think about it. The next question is a follow-up on Mr. Ho's question. Say if there is a reinstatement order and then the employer allows the reinstatement, then the person is then transferred or redeployed to a remote office, or he is subject to various harsh conditions so that he is forced out, or the person is dismissed after 2 or 3 months without a valid reason. what sort of protection is given to this employee? The AEC. Thank you for the question. That's a question asked by Mr. Ho. I think there are 2 points here. If there is a reinstatement or engagement, then that connects with the years of service before the dismissal. It is a continuous contract. That is part of the continuous contract. If the person is re-engaged or reinstated, and if the person is put in a tough condition and the employer tries to force him away, tries to force him to quit, well, this happens from time to time in the workplace, and the case can only be judged according to the circumstances then. In the re-engagement, under the re-engagement order, the person is reinstated, re-engaged, but the person is redeployed to a remote office. Now, the re-engagement or reinstatement is an order issued by the LT, and the LT looks at everything, looks at the terms, and the reinstatement order is only awarded when the terms are comparable, and there will not be a reinstatement order if the terms are substantially different. I think the government has to consider a period of protection or guarantee under the reinstatement order. The reinstatement may be in respect of the dismissal of a pregnant woman. Well, it is unlawful dismissal. There will be a reinstatement order. You don't need to go that far. Now, after the reinstatement order, then the employee may be dismissed after 1 or 2 months. What protection is there? I don't find it meaningful. You don't need to come to this stage. It is not to be handled by the bill. Well, the employer stands to lose.
邵家輝，跟住都係阿啟明，你問唔問第二樣啊？我翻轉頭啦，好嘛？跟住何啟明，跟住就譚文豪行我就。
Next, Mrs. Siu. I want to follow up the case on work injuries and dismissal because of pregnancy. Just said there is no need to discuss it because compensation is the only way. As said by Mr. Yik, the Liberal Party supports the bill, but I still want to speak on this. I've heard many such cases. The public hearing is always was one-sided. The views of the employees were heard, but not the views of employers. Say, for example, I just told you this story. A small contractor gets the workers to do work, and then the employee gets just carry a bale of sand, and then the person claims work injury, and then the claim is made against the employer, and the employer has to pay the employee for 2 years. The employer even has to sew her own flat. Well, there are bad elements. How can you deal with them? How can you make sure that they play by the rules and they will not make use of the rules and then cheat on the employers? Now, you said 8% at the end, only 1.8% out of 8% made a claim. Where after your assessment, you know that it is not UUD. There may be a misunderstanding, of course.
If you ask me, I think the crux of the matter isn't so much whether the further sum should be 3 months wage or $72,500. Some has advocated a criminal liability. Yes, you can make it very stringent. You can say that there will be a death penalty in the case of non-compliance, and then all the employers will be scared off, and then there will be no jobs available. You need to be fair. Hong Kong employers find it difficult to understand the definition of unreasonable and unreasonable and unlawful dismissals. Now, the chair talked about a case dragging on for 3 years. No doctor would say that the pain was still there, and then the employee would always turn down the offers to shift to another position. Who will make a decision? Now, Fernando Cheung says that the decision should come back to the Legislative, but we are not a court. We are a law-making body. We should make a piece of legislation. Now, for the Labour Tribunal, the Labour Tribunal may not be able to make a determination. You need to make it very clear. If you say that a medical certificate will suffice, then we will pay. In the absence of a medical certificate, we'll just see whether it is sensible and reasonable. What if somebody says that he's still in pain 3 months, 30 months, 30 years after suffering the injury? Is it reasonable? I've always emphasized this point. I just want to tell the department that you need to watch out for such cases. Any reply? I think it's a comment from Mr. Shiu. Well, whenever we open a debate like this, both employers and employees will have a lot of grievance to air. The employee suffers physically and emotionally, while the employer has also found that it is a problem they need to deal with. Well, I think probably just now we're all referring to extreme cases. Yes, I've rendered assistance in a number of cases like that. We have handled more than 1,000 employees. The one I referred to was the one that I have encountered. Now, in fact, when pregnancy is known, then the employer would not dismiss the employee, so it is irrelevant to this debate. Yes, as long as the pregnancy is confirmed, then the employee will be fully protected. Well, maybe somebody is not quite clear about the labor laws, or there is misunderstanding, and then that's the problem. Why? I think we are covering the case of UUD. Having heard what members have said, I think it is a point of, in the case of a unreasonable plus unlawful dismissal, then we can apply the provisions. Of course, I refer to a very extreme case, but then if we look at the definitions, if the performance is unsatisfactory, then there could be a valid reason, but of course it can be open to arguments. What I want to ask is, after the court has made an order, what will happen? Can anybody be found contempt of court? Because I understand that if a court order is not being executed by the relevant parties, then there is the possibility of committing contempt of court. Let's be sort of mindful of the time. the question is clear. Give a direct answer, Department. Non-compliance with an LT order, will it be regarded as contempt of court? My understanding is that if the order is not being enforced, then the court has a number of ways to deal with such a non-compliance. Say, for example, relying on a bailiff, as it's a question of how the order will be enforced rather than a question of contempt of court. My understanding is that contempt of court talks about something else rather than whether the order can be sort of enforced. Yes, of course, I understand. If the employer is to act in accordance with the existing legislation, then of course there's no contempt of court. My question is, owing to one reason or other, the employer at the end of the day doesn't comply with the order. I want to know whether he will face the allegation of contempt of court. Ms. Look, currently we don't rely on contempt of court to deal with the situation. The Labour Tribunal may make other orders, like asking the employer to pay the salary or do certain other things. And sometimes employers may not do what is demanded in the court order. Failure to comply with the court order can result in prosecution, and it will be a criminal prosecution. That's even more serious than contempt of court, because it's a failure to enforce the court order. I just want to clarify the point. Yes, the Assistant Commissioner has told you. So under the EO, you would not be invoking the offense of contempt of court for failure to comply with a court order. I just want to clarify this. Yes, that's our understanding as well. Why not? What do you mean? For courts at other levels, we have seen that if somebody fails to comply with a court order, the DOJ will prosecute somebody for contempt of court. Maybe a legal advisor can explain the difference. Failure to comply with court order and also contempt of court. Well, regarding Mr. Wu's question, for information we have got, according to the Labour Tribunal General Rules, Rule 12 says that the determinations and the orders can be registered with the district court. As it stands, it is said that determinations or orders made by the LT may be taken to the district court for the purpose of registration. Say, for example, an order or a determination has been registered with the district court, and in the case that anybody is found to have failed to follow the order or the determination, then according to the district court rules and Rule 415.5, for a determination or order already registered with the district court can result in a remand order. And this is the same process as contempt of court. So in fact there is such a mechanism to enforce it. But of course, first of all, the order must have already been registered with the district court before we will have such an order. Well, as to that particular step, it will mean that we will be going through the court procedures. So that's all I can say according to information I've got. In other words, there is this procedure. It's another matter whether it will be invoked. Yes, understood. Next, Mr. Ho Kai-ming. I think probably this is going to provide more protection to the labor or trade unionists. For the 25 cases in the past 5 years, I want to know how many of them have lost their jobs as a result of engaging in trade union activities. How many of them have been reinstated? You have told us about the mechanism, but can you give us the actual figure? The number of such disputes as a result of speaking up for trade union interests. I haven't got the information with me. Can I tell you in the written reply? Leung Yiu-chung. Well, you need to meet 2 requirements, unreasonable and unlawful, before there is an RI order. Now say the court has ordered RI. The employee has been taken back, and then 2 days later the person is fired. Then at most it is a matter of unreasonable dismissal. It is no longer UUD. So we are repeating the process once again. No, I can't, because in this case it is UUD. You need to be both unreasonable and unlawful. Now say there is reinstatement, and then in a month's time I dismiss the employee, then of course it is unreasonable. But I would be caught out for unreasonable dismissal. The money you get will be 2/3 of your monthly income to be multiplied by the number of years. I think the original benefits cannot be changed. Well, listen to me. Well, for the reinstatement order, the original benefits will not be eroded. Exactly. Do you understand? Say he comes back, he has worked for 2 days, and then he will be dismissed. He will be paid. Yes, but he will only get the termination payments, not much. He can still go to the Labor Department complaining about unlawful and unreasonable dismissal, but it is only unreasonable, not unlawful, because there isn't a valid reason. I think you are going to the extreme. Well, let's talk about the first occasion. It's already a case of UUD, otherwise you won't get a court order. Yes. Assuming that it's because of the trade union activities, but then that matter has been concluded. Nothing happens for the first 5 days, then the employer will say that I don't like him, and so he has been fired. So it is not unlawful. Let me cite an example. I may be handing out leaflets in the canteen of the company to publicize trade union activities. I've been fired, so it is surely a case of UUD because I'm fighting for the interests of the employees or the trade union members. Okay, so it is both unreasonable and unlawful, and the court has ordered reinstatement. All right, that's clear. And then I go back to work. The employer doesn't do anything, and then I get fired on the 3rd day. So it is merely a case of unreasonable dismissal, and then the employee will get compensated within such a category. So unreasonable dismissal and compensation for unreasonable dismissal, 2/3 of the monthly wage multiplied by the number of years of service.
Yes, he can get away with it. He can get away from, he can dodge the issue in respect of UUD. Now, the dismissal then is just unreasonable dismissal, and you cannot prove that he is dismissed because he is engaging in trade union activities. Well, it's not whether it's lawful or not. At least for the court to decide whether it is lawful or unlawful. The previous case has already been closed, or the previous act has finished. Well, I tried to answer Mr. Leung's question. In an extreme situation, the employee is planning very carefully in a devious way. But I think the reinstatement order is issued with the relationship of the employers and employee in mind. If the relationship is too bad, then the reinstatement order may not be issued by the LT. Under Section 32A(5) of the EO, concerning trade unions, discrimination against participation in trade unions, then if there are similar discriminatory acts within the past 12 months, then such incidents will be considered. So it really depends when the dismissal takes place. If the discrimination took place in the past, within the past 12 months, then the dismissal upon reinstatement or after reinstatement, then the employee can also make the claim on the same ground. Since he has already proved that there is discrimination on the grounds of participation in trade union in the first case. Concerning the reinstatement order, is the chance of repeated offense high in terms of breaching the reinstatement order? Say, after a certain period of time, the person can be dismissed unreasonably, but not unlawfully. Unreasonable dismissal includes, say, dismissal because of illness. Well, you have overrun the time given to you. You have to wait in the line again, Mr. Tam. Now we ask for the information on 25 cases in writing. Can you provide information on whether the person suffers from UUD because of participation, because of the trade union, because he or she is a trade union member? The question has been answered. Now, say during the training period, a certain the trainee wants to achieve obtain a certain qualification, but in the middle he is dismissed. He therefore wants reinstatement. But you say the relationship is bad, but if you can suffer that another half year or 1 year, you can get that professional qualification. One may want to suffer for that. When one is under training, one would like to suffer for a few years in order to get the qualification. I'm not saying that all employers are bad, but there are employers who have the mindset, that since the employee is under training for a professional qualification, the trainee can suffer forever at all cost in order to get the qualification. Now, say in a reinstatement or under the reinstatement order, the person is not provided the training. Instead, he is redeployed to another post which is unrelated to the professional qualification. Then he's just paid $72,500 and nothing else, and nothing more. Is it the case? Now let us look at it this way. Now the employee suffers from UUD. The employee suffers other losses. It's not just reinstatement. If the person is reinstated in the same position, then he can continue with the training. Now, if the reinstatement is not possible, the employee will suffer from other losses as well. Then the employee can claim compensation, for other compensation. And that compensation includes the loss arising from the dismissal. So the employee will be compensated for the grievance. Even if one lodges a claim, how much money should he ask for? Say a lawyer. The training period is for 2 years. He has worked for a year, and then you dismiss the person, UUD. This is a UUD case. Then he has to he has to appear before the court, and then he has no time to find other jobs because of that. Then after, say, 1 year or 2 years, now there is a reinstatement order. Okay. You will go back to work in my law firm, but you are not a trainee, not an article clerk, or not. Then you are just redeployed to other places. Now, what kind of compensation will he get? I really don't know how you can have calculate the sums. It's not just the lawyers or the trainee lawyers. I think any dismissed employee will suffer a similar situation. In dealing with UUD, there is a way to claim compensation, and when the LT will have to consider the amount of compensation. And the LT has to take into account the loss that has been incurred by the employee because of the dismissal. The LT will assist the employee in quantifying the loss. Now we will have to end our meeting at 10:30. You have to be precise and concise in asking questions. Mr. Wu, I want a written reply on the following. Now, concerning registering the order in the district court, I want to know whether the LT has registered any order with the district court. I want the numbers. Now, the bill deals with UUD. So in answering the question, I think the official will have to clarify whether it has to be both unreasonable and unlawful dismissal. If this provision, if the case is under this provision, if it is just either unreasonable or either unlawful, then they are to be dealt with under the existing ordinance. Reasonable, unreasonable dismissal deals with capacity or things like that. You have to consider whether the dismissal is both unlawful and unreasonable in order to be caught by this provision. I just want to clarify this. Well, I have to seek your views on the following. Whether we want to pass this bill ASAP, if we want that. And we have one more meeting in July. Do we need a public hearing? We had a public hearing for the bill. The positions are very clear as far as the employees and employers are concerned. And the only dispute is the $50,000 last term. And finally, the bill was withdrawn. Now the LAB adjusted the amount. And the only change is a number. If we have the hearing again, and that will drag the matter on, and you know the consequence. Should we pass the bill quickly, or should we continue to delay? That's number one. It's up to you whether there will be a public hearing or not. You ask people to come up to give their views, but the views are always the same. You just keep talking. The second point is we can only report to the House next at the beginning of next session, and then we can then go to the full council. Now, if we want to be quick, the next session, then we can get it passed within 2017. Otherwise, it will be carried over to 2018. I hope you will take that into account. Mr. Leung Yiu Chung, I saw your hand first, and then Wu Chi-wai. Chairman, whether it's a change of the amount only or not. Last time, there was a view, there was difference in opinion over the amount, and it is really unlikely that LAB will change the amount again. But anyways, you need to let people have a chance to say whether they are satisfied with the amount or not. You should ask them. If they don't agree, then we can oppose, even if we don't amend. So we should listen to the views of the outsiders. You cannot be very fast. Oh, sorry. We are running out of time. Let's extend our meeting by 15 minutes. And then we end our meeting after express your view. After today's meeting, you still have to carry it over to the next session. Okay, I understand your point. Mr. Wu Chi-wai.
其實簡單，第一，我當然想快處理。
Mr. Wu Chi-wai. Of course, I would like to expedite it, but in any event, we can only continue with the work at the new session. So I agree to a public hearing. All right, point noted. If you would like to have a public hearing, we need to give notice. I think the timetable would be tight, so probably we can only have a public hearing at the next session. Can we not deal with it during the rest of the time? We need to issue a notice. I think public hearings can be called at short notice. What do you mean? We have to issue a notice to invite deputations, and then we have to line up the meetings. What date is today? The 16th. And then we will be adjourning for the session in July. I will be out of town after we conclude our business for the session. Well, we can't help it then. All right. We will resume after the summer recess.